what is common law assault or assault itself? The definition of an assault is when a person places another person in fear of actual violence occurring to them. Doesn't have to occur. It can just be the threat of. So 10 points I'd make about it is, one, that definition. Second, the elements of the offence are the person intended to assault somebody, that the person had a reasonable fear that it was going to occur. Those are the main elements of the offence. The third thing that I would talk about is the difference between the assault and battery, which is something you see often in American TV shows. But it really is the act of hurting somebody, the battery. And Australian law or Victorian law is more about the assault and placing somebody in fear of something happening to them. Number 4, verbal threats. A verbal threat is sufficient to constitute an assault. So often we have people come in and say, look, I didn't assault anybody, I was just saying words to them. That can amount to an assault if the person had a reasonable belief that they were about to have the application of force on them. So the waving of a hand at somebody in a threat can amount to an assault. Doesn't always, of course, but the starting point is you could be charged for that. 6, intention required. Recklessness is not enough for an assault. You have to have intended to place the person in fear or apprehension of something happening to them. 7, defences. As with most criminal charges, the primary defence is a factual dispute. We say it didn't happen the way the police are saying it happened. And that's almost always a possible defence in an assault charge. You could also have self-defence where you are defending yourself, hit somebody. The courts are really clear. The term they use is, it's not the Marquess of Queensberry rules. If somebody is assaulting you, you don't have to be very gentle and pushing them away or trying to stop the fight. You're acting in self-defense. So you can't act disproportionately. You can't kill somebody who's just threatening to punch you, but you're not required to act in a particular manner. The rationale for that is obvious. You're responding to what is a really horrible situation and you're doing your best. But it is not a case that whoever wins the fight is the person who should be charged with assault. If you're acting in self-defense, you absolutely can defend the case. Another defense to an assault is you're acting in the execution of your duty. So that could be if you're a police officer or a security guard, or for some reason you need to do what you did. And another obvious defense is consent. So when you see those two people fighting in the UFC, they don't get charged with assault afterwards because they're consenting and it's following the laws appropriate to that. Obviously, those are governed by fairly strict controls. 8, penalty, which is the all-important thing. The penalty for an assault or a common law assault depends on which section you're charged under, because they'll have different maximum penalties. So you might have a charge that has only a 6-month penalty or a 2-year penalty, or depending on the gradation of assault, how serious it is, you might get charged with something very serious, like intentionally causing serious injury. So penalty depends on charge and circumstances, because the likely touching somebody to push them away because you're annoyed with them is obviously very different from them striking somebody with a closed fist. And the courts reflect that in their penalties. They're sensible about how they respond to factual situations. The 9th thing is there's this overlap between summary offences acts, crimes acts, various other places that you'll find assaults, the common law, and it goes to the point about sentencing. That often there's some issues for the police in identifying exactly what happened. And so they might charge you with an affray, because an affray just means people fighting in public and causing people fear. So they don't have to be very specific about the actions of the people. Or they might say, you deliberately did a particular act, and then they'll charge you with something different. So just be conscious. The charges you face often are a good indication of what's in the police officer's mind about how they're going to run their case. 10, aggravating features. As would be obvious, if you're charged with assaulting a child, or you charged with assaulting a police officer, or even in the gradation of offences, an ambulance officer, that carries a more serious penalty. So various aggravating features will increase the amount of penalty you'll get. The absence of those features also decreases effectively the penalty you're going to get. So for experienced lawyers, whoever you might choose to be your lawyer, they should be able to quickly decide, look, this just falls in this sort of band of sentencing. You probably will get a good behaviour bond for it. Or this is so serious and the person has a punctured lung and you've got a history of violence, you're likely to get a jail term. The key thing in any of this is that you want to find lawyers who understand the law, have done a lot of these cases, they're willing to be honest with you about what the outcome would be. We sit in front of people all the time and say, unfortunately, this is going to carry a jail term. But the important thing is being honest with your clients.